Colby Mazzarella. Welcome to Life Matters, where we interview guests who protect human life from conception to natural death. Our guest today is Carolyn MacDonnell. She is the litigation counsel for Americans United for Life. If you want more information, you can check out aul.org for Americans United for Life. Carolyn, welcome to the show.
Thank you so much for having me here today.
Well, you're a litigator. You go to court to defend human life, and can you just say a little bit about what you do before we get into really specific legal news?
Yeah, so I'm a litigation counsel, so I deal with matters of litigation, pro-life lawsuits, both defending the human right to life, but also going on the offense-based side to go ahead and affirmatively protect the human right to life. So as part of my job, we file amicus briefs, friend of the court briefs in courts in high-profile bioethics cases. We also track litigation and analyze it, and just we keep an eye on what is going on in the pro-life movement and how can we go into the courts to defend human life.
Very nice. Now, there's been an enormous change in U.S. law on abortion, so could you give us a quick review of 50 years ago, what did Roe v. Wade actually say? And then what did Dobbs, the case last year in 2022, what did that do?
So about 50 years ago, the Supreme Court engaged in judicial activism, and in Roe v. Wade, they contrived this abortion right within the federal Constitution. Now, the federal Constitution says nothing about abortion, but rather the court went in and they found that you have a due process right and that you can't be deprived of liberty without due process of law. And from that, they extrapolated and looked at, well, it also protects privacy in certain manners. And from that privacy right, they further extrapolated it to create this abortion right. Now, the courts were in disarray for 50 years, trying to understand how to apply Roe v. Wade. In fact, it went up before the Supreme Court numerous times. Again, in the 1990s in Planned Parenthood versus Casey, the court again tried to grapple with Roe, and they actually overruled most of Roe v. Wade and instituted a new litigation test called the undue burden standard. And even that was unworkable. And we had to deal with that for many years and decades. And the courts just couldn't agree on how to apply it. And this abortion standard was just simply unworkable. So last year, the Supreme Court decided Dobbs versus Jackson Women's Health Organization. And in that case, they overruled Roe v. Wade and Planned Parenthood versus Casey. They said that there is no federal constitutional right to abortion, and those cases were wrongly decided. And because of that, what they said is we are returning the abortion issue to the people and their elected representatives. So this is now an issue that has returned to the democratic process. So in the past year, we've been working in the state legislatures and also in litigation to try to understand how to deal with this post-Roe world.
Very good. So a lot of lawsuits were paused while the Supreme Court was deciding Dobbs. They were holding their breath to see if Roe would be upheld or overturned. And what happened to those lawsuits? The people were like, let's hold off on this lawsuit. We don't know what law it's going to have.
Exactly. In a few dozen cases were actually what we call it stayed. That means they were just paused and put on hold because they realized that the Supreme Court might drastically change the law regarding abortion litigation. And as soon as the Supreme Court handed down the Dobbs decision, those litigants in those cases realized that they couldn't continue with the lawsuits. So these were abortion providers who had sued under the idea that pro-life state laws somehow infringed on Roe and Casey's abortion rights. Now, they couldn't continue with this litigation after Dobbs. It became what we call moot. There just wasn't anything at issue any longer in those cases because there was no constitutional right to an abortion. So because of that, the abortion providers actually went in and voluntarily dismissed their own lawsuits. And we've actually tracked and counted at least 30 such lawsuits that have been voluntarily dismissed by abortion providers, which is a great pro-life victory we've had this past year.
Can you just get into a little bit of the controversy? So it's a great pro-life victory because, and what about women's pregnancy resources and issues and things?
Yeah, Yeah, this is a great victory because a lot of these laws were actually health and safety laws put into place to protect women from abortion providers. So we had the admitting privileges laws, for example, that the Supreme Court decided from Texas and Louisiana in Whole Woman's Health versus Hellerstedt and also June Medical Services. And these are also pro-life laws that are put into place fundamentally to protect the unborn human child.
So
And
let me interrupt for a minute. So the admitting privileges means the abortionist under some states' laws has to have admitting privileges where he can smoothly say this woman needs hospitalization and send her right in, and they already have a relationship with the hospital. So that sounds like a safeguard.
Exactly. And admitting privileges are important because it is the standard of care in ambulatory surgical centers that doctors have admitting privileges. Now, in Texas and Louisiana, they found that this was the case except for abortion clinics. So they're trying to bring them up to speed and standardize them just like other ambulatory surgical centers. So that way, if a woman has complications from the abortion procedure, the abortion provider can smoothly get her into the emergency room and she can get the critical care that she needs and she can receive it immediately, which can potentially save her life.
So in Texas, you're saying that anyone who goes into that surgery for whatever it is that could be scheduled and done on a walk-in basis, not an emergency room, that surgeon has to have admitting privileges. But an abortionist, you walk into the abortionist for this surgery, walk-in surgery, but he didn't even have to have any relationship with the hospital. How does that work?
That was part of what we call the abortion distortion, is that somehow when it came to abortion, the normal rules and normal laws that we have on the books wouldn't apply to abortion providers. And unfortunately, while Roe and Casey were in place, these abortion providers would sue and challenge these common sense health and safety laws, and they would win under Roe and Casey's standards.
So are those laws still blocked now that Roe is overturned? Roe's gone.
Well, that's the great news, is now that Roe is gone and Casey is gone as well, there is no legal reason for those laws being blocked. So, for example, in Texas and Louisiana, which we've mentioned because their admitting privileges laws were, held unconstitutional by the United States Supreme Court, those states have gone back in and asked the courts to unblock the laws, and the courts agreed with them. So now those laws are fully enforceable, and this has happened across the board in other litigation as well, where the pro-life states have gone in, asked the courts to lift the injunctions to unblock these laws so that they can go into effect, and the federal courts have agreed with them.
So they're allowing a lot of health protective rules not to be blocked, to actually apply the same to abortion clinics as to other surgeries. What other kinds of protective laws are there that were, as you say, abortion distortion? They were not allowed to protect a woman from an abortionist.
Yeah, we had a multitude of other types of laws on place that were being blocked. So not only health and safety, such as admitting privileges, we had informed consent protections. So if a woman goes in for a medical procedure, any medical procedure, it's a cornerstone of modern medicine that she must give her informed consent. This means she's informed. She understands what the procedure is. She understands the risk of the procedures, and that she's giving her consent, that this is willing and voluntary. She's not being coerced or somehow pressured into giving the consent there. But many pro-life states had informed consent protections on the books, such as reflection periods, such as common sense disclosures of the risks of the abortion procedure. And yet, under Casey and Roe, the federal courts were going in and blocking some of those common sense informed consent laws. And now the great news is that now the pro-life states can go back in and have been lifting the injunctions. They have been unblocking those laws.
So the Supreme Court sent it back to the states, and the states' legislatures are deciding. Some states are voting for more support for abortion. Some states are voting for more informed consent and all those kind of protections for the woman involved. So what is happening when, how are abortionists responding legally to this, both sides, both the states that are more supporting abortion and the states that are more protecting this patient like all other patients?
Great question. So in the states that are already protecting abortion, the states have unfortunately already done the work of the abortion providers, is that they're protecting abortion there. So the abortion providers aren't going in and challenging those laws. But what we do see is that the abortionists are going into pro-life states. And again, Dobbs said there's no federal constitutional right to an abortion, but the abortion providers are now going in and saying, well, let's not look at the federal constitution. Let's look at our individual state constitutions. And they're trying to argue that these state constitutions protect a right to abortion. And there have been at least 13 such lawsuits that have been filed since Dobbs was handed down by the Supreme Court.
So they're saying that the state constitutions protected the right to abortion. Is it actually the word abortion in a lot of state constitutions?
Well, they brought it in different ways. Many of them are premised, again, upon that idea of privacy. Now, our federal constitution doesn't explicitly recognize a privacy right, but we've extrapolated and held that there is a privacy right inherent within the federal constitution. Some state constitutions actually explicitly protect privacy, so they've looked there. They've looked in other regards. There have been some really quirky lawsuits actually alleging religious liberty infringements because certain individuals can't exercise their religion, which requires abortion in certain procedures. So these are pro-abortion lawsuits brought under a religious liberty theory. So they've done a multitude of different types of legal theories here. And what it looks like is really they're trying to protect their abortion rights. And there was no right of abortion at the federal level. And we obviously believe there's no right to abortion at any state level either. But they're trying to devise and create these abortion protections now within state law. Since they lost at the federal level, now they're turning to the states.
So you said public health regulations. I just want to get back to that. It's kind of mind-blowing. There's public health regulations for every surgery that, like, the doctor has to have an admitting privilege, relationship with a hospital that lets him admit his patient of any kind of doctor, any kind of at least ambulatory surgery, walk-in surgery has to have that. So what are some other informed consent? So every doctor, every time you get any kind of procedure done, you have to sign away that you know all the risks. Informed consent, that also includes that you know alternatives to it, or you've discussed it with the doctor?
Yes, it can include alternatives to abortion, because the way they phrase it, they're like at least 1 in 4 women will have an abortion in their lifetime, and that statistic is coming from Guttmacher, which does pro-abortion research. But let's reverse that for a second. The majority of women will not have an abortion in their lifetime, which means that about 75% of women are choosing life. They're choosing to carry their child to term, or unfortunately they will miscarry, but they will not be choosing an abortion in that circumstance. So as part of informed consent, pro-life states are making sure that women understand they don't have to choose abortion first and foremost, that they cannot be pressured into choosing abortion because there are very actual serious risks of intimate partner violence and also reproductive control that coerces women into choosing abortion. But then these informed consent disclosures actually provide state resources and also other resources of, nonprofits such as pregnancy resource centers that can provide women, first of all, community support, but also the material goods and educational courses so they can feel confident in going forward and secure that they can choose life.
Yeah, anytime you go into a doctor, almost any doctor at all, they say, are you being pressured by somebody? Are you feeling safe at home? So isn't that a rule for even more so for abortion clinics? Because it's a domestic issue. It's you could call it a domestic crisis at least, or worry or concern.
There are very serious concerns of this within abortion. First of all, women who are pregnant experience more risks of intimate partner violence. If the pregnancy is unintended, and about 50% of pregnancies are unintended, this also increases that risk of intimate partner violence. And I cite that because many women who are seeking abortion often cite their unintended pregnancies as one of the reasons why they're seeking abortion. You can also have control over the reproductive decisions by family members, again, by an abusive partner. But really, what we're seeing here is that women who are seeking abortion aren't always doing so because they want to do so. They're doing so because they're not aware that they have alternatives and that they can choose life, or they're doing so because it's really the man's decision that she should be seeking an abortion because they're being pressured by an abusive partner or other family members.
Well, I think we've all heard someone say, I have to have an abortion. She has to have an abortion. You have to have an abortion. So it's supposed to be about choice. So isn't informed consent part of it? The doctor's responsibility to say, are you doing this of your own free will? I mean, how does that work in another kind of surgery?
Well, in abortion and versus the other areas, is abortion, we've done these very explicit informed consent disclosures because we're aware that there are greater risks of intimate partner violence. And so that's why we want some of these explicit disclosures that we know for a fact that under law, the doctor is providing to a woman. In other areas of the law, and any other medical area, again, they have to receive the informed consent. And part of the informed consent is that there is consent, which means that a woman or a patient in any type of surgery is not being coerced to undergo the surgery or procedure.
How about knowing the alternative? Because I just recently met a woman who realized she was pregnant and she was far along. And she was 8 months and for various reasons wasn't sure until maybe her 7th month. So she told me that she went into Planned Parenthood and they said, and she asked about her options. And they said, it's on the website. So does that sound like a thorough explanation for informed consent, knowing your alternatives?
Well, that explanation, definitely not. Part of informed consent, again, is the first part, informed, is you have to be informed about the procedure and understand what the alternatives are, whether there are risks with not undergoing the procedure, or if there are risks with undergoing the procedure. But you have to be aware of what alternatives you have to undergoing any medical procedure, let alone an abortion decision.
Yes. So they're going to the states, and I had heard something about some other states in the news. What's happening in Ohio?
Ohio is looking at possibly having a referendum. So this, again, is a question of whether or not states want to modify their constitutions to amend them to either explicitly protect abortion or to go in and say that there is no state constitutional right to an abortion. And a handful of states have done this since Dobbs was handed down last year. Ohio in particular is looking at having a referendum this fall, but they've actually become embroiled in a little bit of a legal debate about having a special election ahead of time. So the November election would have a pro-abortion ballot measure, initiative measure on there that voters could decide on. But they're trying to hold a special election in August that is going to bump that up. Instead of having a simple majority for passing and amending the state constitution, they're trying to bump it up to a super majority, meaning that in this case, they need 60% of voters to affirmatively say, we want a state constitutional right to an abortion. So there has been some litigation, a lot of discussion about how many voters should actually be on there. Was this special election proper? But they're looking at that. But fundamentally, the issue here, again, is does the state constitution protect abortion as a right, which is a very common issue that many states are facing in the courts and other states are deciding via referendum.
All right. Why do you think that abortion is treated differently? You called it abortion distortion in law. Why is the abortion law different from other medical procedures?
I think it stems back to Roe v. Wade. Roe v. Wade was an act of judicial activism. It actually went up on a procedural question. The question was not about whether or not there's a federal constitutional right to an abortion. It went up on a very technical legal question, but the Supreme Court decided to run with the case without having any evidentiary record. And they said, okay, we're going to make this case about whether or not there's a federal constitutional right to an abortion. But because they had no record, they really had to impose their own viewpoints and really decide on the outcome, doing their own research, which is not what judges should be doing. They should rather be taking the facts they have from the records and to decide
from the lower courts.
Exactly, from the
Right.
lower courts. And so in Roe, they decided just to go ahead, create this abortion rate. They instituted this very arbitrary trimester test, which was the justice's own brainchild there. And basically this abortion distortion emerged with Roe because it was completely unworkable. It had no basis in the law. So they tried to keep protecting this abortion right as they devised in Roe, but in doing so, they had to keep distorting the law further and further to keep this abortion right supposedly within the federal constitution. So over the past 50 years, the Supreme Court just mangled all these other areas of law, and it's not even just within abortion. It's all these like First Amendment doctrines such as free speech, other technical legal questions such as third party standing, which means can abortion providers bring a lawsuit on behalf of women if the lawsuit's actually, or if the law is actually intended to protect women from the abortion provider. So like questions of conflict of interest within who's bringing the lawsuit. But yet the Supreme Court and other lower courts had to distort all these areas of law in order to keep Roe's rights secure. And in fact, Justice Alito called this out within Dobbs last year and said that, look, Roe and Casey have distorted these other areas of law, and he lists numerous ones off. Like, this is not feasible. This is not how the law works. We need an even-handed standard. And because of that reason, because of all these other reasons, is Roe has got to go.
Wow. So we only have 3 or 4 minutes left. So I know that a lot of abortions, much more now, with some limits on surgical abortion, they're going to pill abortion. Can you explain that a little bit and what the issues are?
Yeah, so we have the chemical abortion pill or chemical abortion drug. You may have heard it as mifepristone. And what it is a 2-drug regimen. A woman first takes mifepristone, and what it does is essentially starves the baby of nutrients. And then 2 days later, she'll take misoprostol, which causes contractions and expels the baby from the uterus. And so she'll take that. Now, the problem is in this post-Roe world, mifepristone in the chemical abortion drug regimen now makes up just over half of all abortions done within the United States. So there has been some very contentious litigation over that. There also have been very heated questions of law about whether or not you can mail these abortion pills across state lines.
Aren't there some laws about mailing things over state lines?
Yes, there are. If you look at the Comstock law, it actually explicitly says that any article, device, or drug that is used to procure an abortion is considered non-mailable matter, and you can't mail it via the United States Postal Services, and you also cannot mail it via a common carrier. So in this regard, the plain language from a common understanding of what these words mean says you cannot mail chemical abortion drugs. Yet we're seeing that happening right now within the United States.
Another abortion distortion in the law.
Exactly. And abortionists have tried to argue that this somehow doesn't apply. The plain language doesn't mean what it appears to mean, and they're trying to create legal loopholes within it. But again, that's an abortion distortion. The plain language of the law says you can't mail these drugs. That is the federal law that is in place.
Isn't it true that a lot of the abortion pills are prescribed remotely without a woman ever seeing a doctor? And what are the risks for that?
Yeah, so the FDA in the past few years actually allowed the use of telemedicine for chemical abortion drugs, and there are some very serious risks. As we were talking before, there's always the risk of domestic violence and intimate partner violence, which is an informed consent issue, because the doctor's not actually seeing the woman face to face. So he is not able to evaluate the woman in person to see whether she's being coerced to take these drugs. But setting aside the domestic violence issue, which is obviously very concerning, there are also serious health risks to the woman. She needs to go in person to receive an ultrasound. This ensures that evaluates what the gestational age of the baby is, because these drugs are only approved up until 10 weeks of gestation. And in fact, the FDA says, please don't take them after 10 weeks of gestation. That's the only thing we can, quote unquote, ensure for being safe and efficacious. And not only that, but they have to check her blood type. If she has a certain blood type, she needs a RhoGAM shot. Otherwise, she may miscarry her future pregnancy. So that really undermines the idea of reproductive control. But there are very serious health risks that coincide with the use of telemedicine.
So remote phone call, get a pill, no ultrasound, no seeing if you're being coerced, or even people can order the pills online and slip them in someone's drink, so a lot of ways for abuse on that. Well, I know that there are news continuing, and I'll definitely want to invite you back on the show as things develop. And thank you. You're explaining it very clearly. I guess I would just ask one little question. Are there even more risks for a pill abortion, a chemical abortion for minors, for young women, girls?
Absolutely. Minors seeking abortion face very unique risks, in addition to the ones that women already face for chemical abortion pills. But part of the problem that happened with the chemical abortion drugs is when the FDA approved this, they waived the pediatric study. They said that girls are similarly situated with women, so we're not going to perform any pediatric studies and evaluate on them. But yet minors have developing informed consent decision-making processes, which means that they need their parents' guidance on whether or not to take these drugs. And also, by nature, girls are still developing, which means they have high-risk pregnancies oftentimes. And the FDA did not take this into account when they initially approved these drugs and then subsequently deregulated the drugs. So girls seeking these pills face higher risks of medical complications when they take the drugs.
Well, thank you very much. And I want our audience to know that they can find out more information about Americans United for Life at AUL.org. Thank you, Carolyn, very much for sharing this information with us.
Thanks for having me.
And thank you for listening. See you next week on Life Matters.